Court convenes today to honor and remember the life and career of Justice Robert L. Clifford. We are so pleased to be able to welcome Ruth Clifford and Jack, Michael, and their families, and other friends, former law clerks, and partners of Justice Clifford here today. In addition to that illustrious group, there are a number of retired justices of the court, as well as Chief Justice Poritz and Chief Justice Zali, who are here or will soon be here. I know that Tom Scrivo, Chief Counsel to the Governor and a former partner, plans to be here as well, so we'll welcome him in advance. And Walter Timpone, wherever you might be seated, we welcome you and very much look forward to your joining us here on a regular basis in the not-too-distant future. Your presence, all of you, is but one sign of Justice Clifford's lasting influence on this court and its members and on the entire legal community. Now, this afternoon, we're going to have a chance to hear from some special guests who will share their memories of Justice Clifford. I'm sure that they'll speak about his service on the court for 21 years, as well as his exemplary role in the legal community throughout his service. Let me start with just a few words about his continuing contribution to the court today. When I arrived, I had heard about his famous wit, about his reputation for scholarship, dignity, elegance, and his role as the court's grammarian and editor was not only widely known, but it remained a force and continues as of now. From time to time, as members of the court would wrangle over just the right way to say something in opinion, invariably someone would say, "This is what Justice Clifford would have done," and that would settle the matter. I took that to heart, and when I completed my first opinion, and it went out as a published opinion, I sent it to the justice and asked him if he wouldn't mind marking it up, having a read, and editing it. And he did just that. He readily took up the challenge, sent it back in a few days with a fair amount of ink spilled in a number of spots, fair comments all, and I have been told since by a number of individuals that he was gentle in terms of the number of comments that he offered. But one edit stood out above all of the others. It was a 17-page opinion with one footnote. And even that solitary footnote was too much for the justice. He sent it back, and beside the footnote, in big, bold letters, capitals, were N-O with 4 or 5 exclamation marks next to it. And each time that I've inserted a footnote to an opinion, and I'm from the Clifford School and try not to do that, I always imagine the grade that he would be giving me if he were going to be reading it and evaluating it again. A few weeks ago, I asked Donna Anapete, whom I'm assuming everybody here knows, who served with the justice and has a wealth of knowledge about the court, if she had any stories that she could relay about the justice. And she gave me a letter that Justice Clifford had written to Stephen Townsend, then clerk of the court. Stephen, we're so glad to see you here today. And it was a letter asking him to replace a draft opinion that he had previously circulated with a new one for filing. Just by way of comparison, those letters usually say something like this. Dear Stephen, enclosed, please find for filing the dissent in Smith versus Jones. Very truly yours. This letter by Justice Clifford, dated December 23rd, was a little different. It related to a debate about the word volunteer and the meaning of the concept to volunteer in an opinion. And the letter really speaks for itself about the justice's magnificent and inimitable style. Here's what he wrote. Dear Steve, I've returned from the woodshed, bloody and bowed, admonished, chewed out, and thoroughly cowed. Tear up that filed draft the High Sheriff proclaimed. If that ever goes public, this court will be maimed. Compliant, submissive, sans hint of a jeer, I've tried one last time to explain volunteer. My prospects are winning, are skimpy for sure. More likely they'll see me as wimpy, but pure. Pure as the snow that arrives with the season. The High Sheriff's bidding is good enough reason to abandon conviction and show some good cheer, to bask in the joy of a happy new year. So forget my first effort, give all my sibs glee, just file this revision, your friend, RLC. One of a kind. We're fortunate to be able to hear from a number of individuals this afternoon. I'd like to call first on retired Associate Justice Gary Stein, who will offer remarks on behalf of the current and former members of the court. Justice Stein.
Thank you, Chief Justice, and may it please the court. It's such a delight to see so many of Justice Clifford's former clerks come here to commemorate this occasion, but I was thunderstruck when I was greeting visitors out in the lobby to shake hands with Jeff Clemente, who clerked not for Justice Clifford, but for Justice Mountain. And those two justices were quite close, and Jeff came here from Tokyo to be here for the occasion, so that's another indication of the affection and esteem in which Justice Clifford is held by so many. The justice whose memory we honor today, Robert L. Clifford, was as proud of his membership on this court and as dedicated to the preservation of its reputation for excellence as any justice I have known. In addition to his 1 year of service as a law clerk to the late Justice William Wachenfeld, Justice Clifford served on this court for 21 years, from 1973 to 1994. His tenure was the third longest in the modern court's history, exceeded only by Justices Nathan Jacobs and Alan Handler. At the time of his death on November 29, 2014, he was 2.5 weeks shy of his 90th birthday. He was survived by his 3 sons, Rob Jr., Jack, and Michael, 7 grandchildren, a great-granddaughter, and his wonderful wife, Ruth, who lovingly and devotedly helped him navigate his last few years when his activities were limited by illness. For 10 of those 21 years of his service on the court, 1985 through 1994, he and I served and participated together in this court's deliberative and decisional work. His influence was enormous. He was among the court's least predictable justices. Because he had spent most of his legal career as an insurance company defense attorney, he was an unlikely champion of plaintiffs' rights, nor was it expected that he would turn out to be a stalwart protector of the constitutional rights of individual citizens. He was neither a liberal nor a conservative justice, but his votes and opinions were shaped by a strong belief that the court's decisions, although informed by law and precedent, had to conform to an overriding standard of fairness and justice. A sample of his majority opinions illustrate his vast contribution to the court's jurisprudence. In 1981, he wrote the majority opinion in Beck versus Beck, holding for the first time in New Jersey that trial courts in child custody cases were authorized to grant to divorced parents joint custody of their children. In Smith against Ricci, he wrote the court's opinion upholding against a free exercise and establishment clause challenge, a State Department of Education regulation requiring all school districts to develop and implement a program for teaching family life and human sexuality in the public schools. In State v. Hempeley, he wrote the court's majority opinion holding that under our state constitution, law enforcement officials needed a search warrant based on probable cause before they could conduct a search of household garbage left at the curb for pickup. With characteristic understatement, his opinion acknowledged the fact that the United States Supreme Court and the vast majority of other state courts disagreed. He wrote, "We are aware that our ruling conflicts not only with the United States Supreme Court's holding in Greenwood, but also with the holdings of virtually every other court that has considered this issue. Although the weight of the cited authority is impressive, our thorough consideration of the issue leads us to record our respectful disagreement with those courts that have reached a result contrary to ours. In State versus Hartley, where's Mary Thurber? There she is. Judge Thurber was Justice Clifford's clerk when he wrote this opinion. Defendant was the lookout for a jewelry store robbery that resulted in a double murder. He had invoked his right to remain silent after receiving Miranda warnings at 7:30 and 9:15 on the morning of his arrest. At 10:40 a.m., an FBI agent approached Hartley and, without administering new warnings, told him that if he was going to make a statement, now is the time. Hartley confessed, and in a 5-2 decision written by Justice Clifford, the court held that the confession was unconstitutionally coerced because the FBI agent had failed to re-administer Miranda warnings when he reapproached Hartley and therefore failed to scrupulously honor Hartley's right to remain silent. That might have been the last time I dissented from one of his majority opinions. And in Millison versus DuPont, Justice Clifford's opinion for the court held that although the Workers' Compensation Act provided the exclusive remedy for employees injured at work, the act did not bar employees from filing civil suits against DuPont based on allegations that company doctors fraudulently concealed from the employees the fact that they had contracted asbestos-related diseases. One of his best-known opinions was Dewey versus R.J. Reynolds Tobacco, an extremely controversial case in which the court held that the federal law mandating health warnings on cigarette packages did not preempt a New Jersey common law claim for damages based on the dangers of cigarette smoking. The cigarette companies had argued that because of the federal law, the consumers of cigarettes had been made fully aware of the dangers of smoking. Justice Clifford's opinion for a unanimous court squarely rejected the contentions of the tobacco companies, including the argument that Congress, by passing the Federal Cigarette Labeling Act, intended to preempt all state law claims. He wrote, "Defendant's argument completely ignores the extensive efforts of the tobacco manufacturers to saturate the public with information regarding the benefits of cigarette smoking, the aim of which is to rebut the assertions of public health advocates and the Surgeon General. Public opinion surveys, as well as Federal Trade Commission reports, suggest that the tobacco companies' efforts at rebuttal have been successful, thus raising a material issue of fact regarding consumer awareness of the dangers of smoking. We are unable, therefore, to conclude that as a matter of public policy, manufacturers of cigarettes should be immunized from liability for the harms caused by their products." During our years together, Chief Justice Wilentz often assigned to Justice Clifford some of the court's most controversial opinions. After the death penalty was reinstituted in New Jersey in the 1980s, the Wilentz court reversed the first 30 death sentences imposed by trial courts. And many of those reversals were the result of Justice Clifford's opinion for the court in State versus Gerald. The state legislature was so incensed by that opinion that it passed a constitutional amendment in the mid-90s to reverse it, but it had little impact. In Gerald, the court invalidated as unconstitutional a provision in the death penalty statute passed by the legislature authorizing the death sentence for a defendant who intended not to kill, but to cause serious bodily injury that resulted in death. Defendant Gerald, during a house burglary, had assaulted one of the residents who died from the injuries inflicted. But the jury that imposed the death sentence made no finding on whether Gerald intended to cause death or intended only to cause serious bodily injury, which resulted in death. The statute and the trial court's instructions nevertheless permitted Gerald to be sentenced to death, and he was. Justice Clifford's opinion for the court struck down the death sentence. He wrote, "Our society's ultimate sanction, the death penalty, is properly imposed on those who act with the most culpable state of mind, namely, the purpose or knowledge that their victims will die. For those who act with a less culpable state of mind, i.e., an intent to inflict only serious bodily injury, with no intention that death be the result, a lesser sanction is mandated by our state constitution." Those opinions provide a glimpse of Justice Clifford's work product during his years on the court. But as I'm sure everyone here knows, his contributions to the court's opinions went far beyond the ones he authored. During the 10 years we served together, and beginning many years before that, Justice Clifford edited, both for grammar, blue book style, and substance, every opinion circulated by every member of the court, adding innumerable hours to his already burdensome workload. He explained to me once that editing was irresistible to him, and that he also edited Time magazine whenever he read it. Maybe so. But I can attest to the fact that his edits were of incalculable value to the quality of the court's work, not only the opinions, but the writing ability of every justice and every law clerk exposed to Justice Clifford's merciless red pen were permanently enhanced by the experience. In my own case, practicing law currently in a firm with 30-some attorneys who frequently ask me to edit their briefs, not 1 week goes by in which I do not change a which to a that, or vice versa. Relocate the word only to a position later in a sentence. Substitute although for while. Change these to those. Replace since with because, and substitute concerning for as to. Every one of those corrections for me is reflexive because they were drilled into my subconscious by Justice Clifford's repeated and unyielding corrections of my draft opinions. Nor was Chief Justice Wilentz immune from Justice Clifford's red pen. He once objected to Justice Clifford's insistence that he hyphenate certain words in one of his opinions. That prompted a detailed letter from Justice Clifford to him dated March 14th, 1986, and a reply from Chief Justice Wilentz dated March 20, 1986, both of which were preserved thanks to Donna Anna Pete, who worked with Chief Justice Wilentz and every other Chief Justice after that. Justice Clifford's letter read in part, Quote, "My own view is that almost invariably when one uses a composite adjective made up of an adjective and a noun, as in, say, low-income housing, the hyphen is indispensable to an understanding. More so when you stretch it out to low and moderate income housing. In my case, because the eye and the mind don't coordinate too well as you go from the start of the phrase to the end, so without the hyphens, I would end up rereading and doing a lot of eye shifting and all that other stuff that hyphens help one to avoid. Which is not to say that a hyphen is necessary to an understanding of the expression when not used as a composite adjective, as in low income, parenthesis, which, by the way, is what the judiciary is doomed to unless something good happens pretty soon. Chief Justice Wollentz surrendered 6 days later. His reply reads, Ray, hyphens, Dear Robert, please be assured that I am prepared to cave in completely on any aspect of the above-mentioned subject. I wanted only, sick in parenthesis for the only, to assure you that my reaction to your recommendations was both rational and conscientious, even though misguided. Please do not send me any more instruction on this particular aspect of the subject. I've absorbed all I can and feel the need to go on to some other matter. Commas, perhaps, in which our talents might be more evenly matched. I do think, however, wrote Chief Justice Wollentz, that our exchange has helped me catch on, hyphenated, to this particular mystery, sincerely. That correspondence with Chief Justice Wollentz highlights another of Justice Clifford's unique but unheralded contributions to the effectiveness of the court on which he served. Despite the seriousness and perseverance with which he prepared for the court's oral arguments and conferences, his wry sense of humor and delightful wit enlivened our time together and created an atmosphere in which there simply was no room for friction. In addition to the Chief Justice, he bestowed a nickname on each of his colleagues. Justice Handler, not our tallest member, was Stretch. Justice Stuart Pollock was Grover, so named for New York City's official greeter, Grover Whalen, because Justice Clifford thought Justice Pollock said hello to everyone he met. Justice Daniel O'Hearn was the mayor, or Monsignor. Mayor, because he had been mayor of Red Bank for 10 years, and Monsignor, because he edited out racy language from any opinions involving sex. Justice Garibaldi was Doc, because no one received as many honorary degrees, and I was Wall Street, which was where I began my legal career. Whether it was tossing a paperclip to awaken a dozing colleague during a conference, or recoiling with mock horror when I brought a batch of oat bran muffins to elevate the quality of the court's lunch, he consistently managed to keep tension and conflict far from our deliberations. A classic example of his style was revealed in Justice Daniel O'Hearn's book on the Wollentz Court, when he quoted portions of Justice Clifford's formal, official report to Chief Justice Wilentz about a conference the chief had missed because of a trip abroad and that Justice Clifford had presided over. And here's what he wrote. One might think from the above that I enjoyed a modicum of success in getting through the ministerial business of running the calendar. Little did I know the disaster that awaited on the administrative stuff. How do you stand these people? I cannot bear to tell you any more than that your suggestion for immediate revision of the Ethics Financial Committee rules was roundly, and I mean roundly, rejected. Far be it from me to tattle, but Justice Garibaldi persuaded us all to ignore your recommendation. Justice Handler insisted that we ignore it. Justice O'Hearn wishes that we do whatever it is we are going to do tastefully. And Justice Stein, with what he perceives, parenthesis, hallucinates, as a dose of practicality, allowed us how the Ethics Financial Committee cannot do much to hurt us. Now, look, don't blame me. I just work here. Likewise, in respect of your thoughtful suggestion on In Re Opinion 26 concerning real estate closing practices, the hostility that your recommendation engendered is so embarrassing that I cannot recount the members' reactions in detail. Shaken, I asked that it be held for February 1st so that those people could screech at you instead of me. They cannot pay you enough for this crummy job. We all hope that you enjoyed a long rest, paid attention to your diet, and that your too brief separation from your colleagues, painful as you may have found it, will produce a congenial and indulgent attitude in the face of our manifold shortcomings on your return. Signed, Clifford J. King for a week. So if ever a justice did it all, conscientious and meticulous preparation, authorship of elegant opinions, a prodigious work ethic, including hours of extra work editing our opinions, and all the while enhancing morale and collegiality with a sharp and penetrating sense of humor. That was Robert Clifford, a man whom Justice Daniel O'Hearn characterized in his book on the court as the indispensable justice. And so he was. For me personally, he also was an indispensable friend. Thank you.
Thank you, Justice, for those beautiful and heartfelt remarks. Let me give you a brief update on how we have proceeded on some of the very themes you mentioned. Every now and again, the court rejects wise suggestions for administrative matters, roundly rejects suggestions that come from the chief. I guess it's a tradition. Justice Fuzzy is working on nicknames for the rest of us. We'll see how far he gets. And as I was looking at you read those letters about the use of hyphens, Walter Timpone is squarely within my ambit, and if I read his smile correctly, he was shaking his head wondering, what am I about to get into? So I hope you haven't scared him off. It's a special pleasure to welcome Judge Katharine Sweeney Hayden, United States District Judge and a former law clerk of Justice Clifford.
May it please the court. Justice Clifford retired from this court the month that he turned 70, which was December 1994. By that time, as we've heard today, he had been an associate justice for some 21 years. In December of 1994, no member of this court, as currently constituted, was serving on it. Justice Rabner was rising to prominence in the U.S. Attorney's Office. Justice LaVecchia had recently become the director of the Division of Law. Two members of this court were partners at prominent law firms in New Jersey, Justice Albin at Wilentz and Justice Patterson at Riker. Justice Fernandez-Vina was beginning his service on the New Jersey bench, and Justice Solomon was a member of the General Assembly, and Judge Cuff had just been elevated to the appellate division. Not surprisingly, and most respectfully, I would describe these illustrious careers as life in the legal fast lane. I think you'll recall there was nothing about Robert Clifford that was out of touch with life in the legal fast lane, then or ever. Throughout his many years on this court, he bristled with relevance in his opinions, in his interest in the law as it was being practiced, and in his passion to write and edit with precision, so that however imperfect we are as human beings, the court, when it decided a case, got it right. Such is the fate of the law clerk, that I will be forever dazzled by him because he was my judge. And so when I share these remembrances, you'll understand where they come from. That said, I miss him more now than I did when I spoke at the memorial ceremony in January of last year. I miss him more each year. There really are people whose like we will not see again. I first saw Justice Clifford when he, Judge Garth, and Justice Sullivan were gracious enough to sit on the finals of Seton Hall Law School's appellate moot court competition. The argument was held in one of the courtrooms on the third floor of the Lautenberg Courthouse, then the old post office building in Newark. He was in his first year as an associate justice with chambers in Morristown, and of the three jurists, he drove the furthest to get to downtown Newark. My partner, Bill Staley, and I won. Did I, a second semester of second year student, follow up with an application for a clerkship? Not on your life. Eddie Matthews saw me in the Pathmark in Maplewood that June and asked if I had, and I muttered something about getting around to it. And Eddie asked me again a little while later, and then he looked me in the eye and said that Justice Clifford had suggested that perhaps I might apply and that this doesn't happen every day. Just remembering how sublimely dumb I was truly makes me cringe. I'm cringing now. That would never happen. But think how cringeworthy truly his offer of a clerkship was. There weren't that many women law students around, nor were that many law students who were embarking on a second career and had a family, and surely there weren't that many applicants without law review credentials. And Seton Hall was only just beginning its rise as a law school to be reckoned with. And he was brandy new. And oh, those early years as a judge, no matter on what court, are really, really tough. My word, he took a chance. Of course, it was the best year of my legal life. All of us here, all of the law clerks agree. We know that. And at least I had the wisdom to know that as it was happening and to mark the day in March that was essentially hump day, because every day that followed was dragging me and my co-clerk, Joe Cott. Where are you? Where is he? My co-clerk, Joe Cott. We were being dragged inexorably to the moment that we would walk out of chambers and into life as lawyers, without the shelter of Ruth and the goading of our prickly judge, who pretty much taught us all we knew. Wherever we came from, the Clifford clerks in attendance here all share the same experience. The dawning recognition in the fall of the clerkship that we were in a special relationship with special people, the judge and Ruth, and that we had older and younger siblings of a sort, the clerks from the other years. And then as the clerkship year went on, and in the ensuing years when we get together, came the full flowering of the boneheaded, arrogant conviction that our year, without question, was the best one that the judge and Ruth ever had. Right? And they never let us down in that blind belief. I miss him and those precious times more each year, and I wrestle with why. I know that whatever a Clifford clerk learned about the law and lawyers and the practice of law wasn't furnished by self-conscious preaching or by scaring us straight. Rather, the judge and Ruth were themselves, always. Not suffering fools, but never petty. Meticulous about the craft, but never mean-spirited. Endlessly tolerant of our clumsy efforts to manage the prestige of the position his clerkship represented, so that we turned out to be a group of self-deprecating, but confident and finally fine lawyers. We modeled ourselves on him, and we leaned on her, and year after year they guided us and then gently disengaged us. They did that with food. They did that with fun. We know how much we laughed. And with an open door, always a wide open door, so that after we tittered out, we could always slink in or bound in, but never strut. Ultimately, we learned a lesson that perhaps our profession has lost faith in: humility. He made it clear that one does not take for granted the great privilege we had of being with him and of being lawyers at all. That our foibles could trip us up, and so be very, very grateful for a smooth ride and have compassion for those who stumble. And get up and without rancor push on when we ourselves stumbled. No, he never said that. He showed it in his dealings with the countless friends who'd stop by chambers, with the other members of the bench, with the stories he'd tell that were full of affection, even as they were richly funny. He showed us with his fierce loyalty to the judges he admired, Justice Mountain, Chief Justice Hughes. The lawyers who came after Joe's and my year can add to that list. And he showed it in his fierce loyalty and love for the lawyers he practiced with, and with his deep understanding of what a lawyer's life is made up of. I came to understand in retrospect why he closed the door to his office, something he rarely did, and labor over ethics decisions we were never a part of and that he never talked about. Always, he demonstrated his affection and respect for the entire court family, every person who made the Supreme Court function, and every employee in the Morris County Courthouse. We learned manners, if we didn't have them already, and we learned that this elegant, wonderful-looking man, perfectly turned out in his irritatingly understated, always correct attire, could connect with each person he encountered and make that encounter warm and easy, for no other reason than it mattered. When you think of it, in those remarkably few months, he taught us that scholarship matters, and because of that, grammar matters, and at all times, manners matter. And that is priceless knowledge he instilled in each of his clerks. With that recognition, late last night I finally resolved why my sense of him is so keen and getting keener. It isn't missing him exactly. That tug is coming from his restless spirit, growling, harumphing, editing, pushing at me not to get soft, not to get comfortable, to make it better, to be disciplined, to reason, to cull, to fuss, to create, listen, try. Got it. We get it. Every lawyer, every judge has his and her special moments. I've been privileged to be a judge for 24 and a half years now, and I've had mine. And thankfully, I've outlived those and come to realize that the best came first when in November of 1991, wearing my nice green swearing into state court outfit that was a little over a month old, I married Ruth and the judge. It does not get better than that. And the restless heart he gave to Ruth knows that perfectly well. Thank you, Ruth. And hey, our judge, thank you.
Thank you. No doubt many of us in this room who had the privilege to clerk approached the beginning of the clerkship as you did, thinking, boy, our judge has taken quite a chance on us. But having appeared in front of you for many, many proceedings in federal court, I think Justice Clifford knew the odds were in his favor when he made that selection. We welcome next Lauren Starkey, niece of Ruth and the justice, who will speak on behalf of the Clifford family.
May it please the court. Bob was many things to many people. To some of you, he was a colleague, a friend, and a mentor. To a few of us, he was a father, a husband, a grandfather, and an uncle. Ruth asked me to share today some memories of him at home. And by the way, I know if he's listening, he hates this already, but here goes. Bob was notoriously difficult to buy presents for. For years, his suggestion to Ruth for birthdays, Christmas, and anniversaries was red Jell-O. My mother always made it for me, he would remind her. The year Gordon and I got Bob's name in our family Christmas gift lottery, he said, as I expected, I don't want anything. But then he had an idea. He asked for a V-neck, cashmere sweater, orange, size medium. Thanks, Bob. This was before Amazon, and I live in Vermont. Not a lot of shopping experiences there, but we did manage to find the sweater, and he loved it. Bob was more enthusiastic when it was someone else's birthday. In fact, he and Ruth never missed one, and she still doesn't. The call would come sometime during the day, a duet of happy birthday with piano accompaniment. Whether we were lucky enough to catch it live or listen to it on voicemail, it was always a treat. Ruth says that Bob was her college education. He introduced her to jazz and opera and helped her with her writing. In fact, as everyone has mentioned so far, Bob took his position as grammar policeman very seriously, and it's a role many of us are familiar with. Dinner conversation could include a rant or two about nominative and subjective pronouns, split infinitives, or punctuation. So I was a little more than nervous when Bob asked for a copy of a book I wrote on grammar and usage 10 years ago. I should have known that it would be returned to me, edited in red pen. But it's still a point of pride, though, that most of the errors he found concern my misuse of the word only. No misplaced modifiers, no confusing the words that and which, no faulty comparisons. I felt I passed the test. When they were home, Bob and Ruth loved their weekends. After breakfast on Saturday morning, Bob would head upstairs, armed with the boxes Charlie had delivered on Thursday containing the court's work for the following week. He went to his office on the right, and Ruth went to her sewing room on the left. They met for tea in the morning, and then again for lunch. He might have a nap, and Ruth would listen to the opera, and they met again for cocktails and dinner at 6. My aunt says the routine was identical on Sundays, minus the opera. These infamous homebodies did, however, venture out on occasion. One of Ruth's favorite memories is of their trip to King's College, Cambridge, for the Christmas Eve service, a retirement gift from their law clerks. Ruth had introduced Bob to the broadcast of that service years before, and he said that someday he would make it there. The clerks made that possible. That wonderful trip stands in sharp contrast to the one they made to Scotland 5 years later for one of our family weddings. He said afterward that he didn't realize what he was getting himself into. Scottish country weddings last a week during which he understood not one word of what anyone said. Ruth played the role of translator. Bob also loved to eat. I'm sure many of you know this, and Ruth loved to cook for him. He enjoyed food to the very end. Thanksgiving morning, he had his usual breakfast of soft scrambled eggs. By the afternoon, our whole family was there for dinner. He sat down at the table with us, but just before the meal was served, he decided to go to bed. We didn't know then that that breakfast was his last meal. As always, though, it was, as he said, good eats. Thank you.
Thank you, Lauren, for that lovely tribute, and thank you to everyone for attending and participating in this memorial service. We are going to retire to the conference area. Please join us. Court is adjourned.